for joining us to honor this year's Constitutional Champions. A special welcome to our past champions who are here tonight, Ambassador Tom Pickering, Judge Pat Wall, and renowned lawyer Abe Crash. Welcome also to some of our other special guests, the Chief Judge of the Ninth Circuit and my law school classmate, Alex Krasinski, Federal District Court Judges Paul Friedman and Emmett Sullivan, Jerry Fisher and Richard Levy, and members of the Privacy and Civil Liberties Oversight Board. Tonight, I'd like to discuss the Constitution's role in our country's political struggles. Serious commentators have wondered whether our government is beyond repair, so paralyzed and consumed by partisan warfare that it can't even address today's most pressing issues. Many politicians use the Constitution as a partisan tool in these struggles, accusing some vague other side in these struggles of violating the Constitution, sometimes even questioning their loyalty. I wonder whether those who deploy the Constitution this way have actually read it. Do they understand that it is our national charter, an instrument for cohesion and consensus rather than a political cudgel? The Constitution does not dictate political outcomes. It's a neutral framework that sets the ground rules for debate and protects individual rights against the tyranny of the majority. Think about what a resilient and timeless document the Constitution is. Yes, its text has been invoked by the U.S. Supreme Court to support some of our country's most shameful actions. Plessy versus Ferguson upheld the separate but equal doctrine. Bowers v. Harwood upheld discrimination based on sexual orientation. And Korematsu versus U.S. legitimized the detention of Japanese Americans during World War II. Yet in each of these instances, and many others, the court and the country have recognized its mistakes. While it's an uneven path, the Constitution has historically guided us toward more equality, liberty, and justice. Plessy v. Ferguson became Brown versus Board of Education, and racial barriers fell. Bowers v. Harwood became Lawrence v. Texas, and legal prejudice on the basis of sexual orientation waned. Korematsu, though never formally overturned, has been thoroughly discredited. So I hope that the current public disenchantment with our government and the use or misuse of the Constitution to express that disenchantment will diminish, and we will find our constitutional equilibrium again. The beauty of our Constitution is its simplicity, but that means that there may be no clear answers about its meaning, and we're left to disagree about many things. I'm not saying we can easily resolve many of these disagreements, that there is a lot of work to be done. But the Constitution has proved that unlikely allies from the right and the left, Republicans and Democrats alike, can come together to agree about basic constitutional principles and safeguards. The Constitution has made this goal our mission and has given this work a home. We've led the way in so many areas in educating policymakers and the public about the Constitution, helping move us away from bipartisanship and paralysis and toward vital bipartisan consensus. Last year's work is among the most important we've ever done, and I'd like to highlight some of it for you. Despite the best efforts of many to convince the White House or Congress, they refused to examine our country's actions regarding the detention of suspected terrorists. So we acted, the Constitution acted, creating our bipartisan task force on detainee treatment, which includes some of the most experienced, able, and influential people in government, law, medicine, diplomacy, religion, academia, and military. It examined our actions from the Clinton to the Obama administrations, and its creation was a controversial decision in some quarters. But it was the right decision then, and the reaction to our report from all over the world confirms just how right it was. A year ago, the task force issued an uncompromising report, concluding that our government had engaged in torture, not enhanced interrogation, not abusive techniques, or whatever other euphemism politicians and press have used. It was torture, and it was authorized at the highest levels of our government. As with all our reports, we used the task force report to further our education and advocacy work. Task force members persistently urged the Senate Select Committee on Intelligence, or SISI, to release its report on the CIA's actions. Just a couple of weeks ago, the committee finally voted to do so, but the report must still be declassified, and it may be a very long time before it sees the light of day. So our report remains the only public documentation of the terrible actions our government took in our name. Task force members and DCP staff have also successfully supported fewer restrictions on the transfer of detainees to foreign countries, another step toward closing Guantanamo. We convened a conference of medical experts, ethicists, and others about the disturbing role played by medical professionals in torture and related activities, and how to make sure it never happens again. Alberto Mora, who as many of you know is a true hero, and who as the Navy's General Counsel blew the whistle on torture in 2002, and was our 2009 Constitutional Champion, sent me an email just after the Sissy vote. He said, "Dear Ginny, in the glow of satisfaction and patriotic pride at the Intelligence Committee's vote yesterday, I could not help but remember how important the work of the Constitution Project was to yesterday's outcome. As I've told you before, in my view, the task force's report on interrogations has been the single most important contribution to date to our nation's understanding of what happened. It's reactions like that that make me so proud of the Constitution Project, its volunteers, its staff, and our work." Another example of our consensus building is our criminal justice work. We've long brought together liberals and conservatives to support the Bill of Rights. Our death penalty committee, for example, includes opponents and supporters, experts in every part of the system. On May 7th, we're releasing Irreversible Error, the committee's updated report, written with the invaluable help of the law firm of Aiken Gum. Presenting the report will be Mark White, a Democrat who, as Texas governor, oversaw 19 executions, and Republican Mark Earley, who oversaw 36 executions when he was Virginia's Attorney General. Governor White and General Earley have come together like the rest of the committee because they know we face a profound risk of convicting and executing the wrong people, including people who are entirely innocent. They'll be joined at our event by one of those people. Anthony Graves was convicted of multiple murders in Texas, served 18 years in prison, 16 on death row, and 10 in solitary, before a special prosecutor found no evidence to link him to those crimes. In 2010, he was exonerated and released. Our report says you don't have to oppose the death penalty to know that a system that produces such terrible injustice is truly and profoundly broken. Just last month, we convened over 20 prominent evangelical leaders representing huge numbers of congregants nationwide to preview our death penalty report and discuss the many other criminal justice reforms we addressed. We started the meeting knowing that the attendees held various views on these issues. We ended it with all of them agreeing to join our unique clearinghouse of unlikely allies on criminal justice reform, which now has over 500 active members, former prosecutors, policymakers, judges, prison officials, and other influential experts who we connect with our partners nationwide to help with activities such as legislative reform efforts, clemency petitions, litigation, and public education. And then there's privacy. Even before the Snowden revelations, we were working to protect the privacy and civil liberties of those of us, pretty much all of us, who use virtually any kind of technology. We're meeting with federal and state governments, arguing for more accountability, transparency, and control on activities such as the use of drones and DNA testing. We're demanding limits on government and corporate snooping, especially since it's often without our consent or even our knowledge. And we're insisting that surveillance be allowed only when it is legitimately and absolutely necessary to protect our safety. These issues, which are coming to define our society, are a major new Constitution Project focus. Who owns this information about us? You? The government? The phone company or the business that you're doing, the store you're doing business with? What can be done with it? Can it be kept on file forever, sold or given to your health insurance company or a prospective employer? In these areas and a host of others raising constitutional questions, we work with partners nationwide organizing statements, testimony, and amicus briefs involving, for example, bad lawyering, intellectual disability in criminal cases, Brady violations, privacy invasions, harsh sentencing, challenges to the no-fly list, and secret lawmaking. It's thanks to our amazing staff that such a small organization can accomplish so much, and I'm so grateful to all of you. And Maria Cortina, a new staff member, is translating our work into Spanish, making sure that it reaches the fastest growing population in the country. I want to thank our board of directors for their time, expertise, and support, but I want to single out one person, the creative, tireless, and indomitable Jenny Donnelly, who is our development coordinator, and he has led us to the most successful gala we've ever had. Finally, I'm so grateful to our constitutional champions who have performed a vital service to our country by standing up for the Constitution and the rights of all of us. For more about our first honoree, Gary Pruitt, please welcome Gracia Martori, Gannett's President and Chief Executive Officer, who serves on the Board of Directors for the Associated Press.
No, I think I have a height advantage, apparently. Well, thank you very much, Ginny, and I'm delighted to have the opportunity to introduce Gary Pruitt this evening, President and CEO of the Associated Press, who tonight is being honored as a Constitutional Champion Award. This award recognizes individuals and organizations who have dedicated themselves to defending our nation's Constitution and the principles it embodies. And I think it is incredibly fair to say that Gary and the Associated Press did just that last year. They stood up to the Department of Justice after the DOJ notified AP that it had secretly swept up records from nearly 24 AP phone numbers over a 40-day period as part of a leaks investigation. This was a chilling disclosure to the AP, an organization dedicated to fighting government secrecy. As we know, these are challenging times for press freedom, and Gary had just taken the helm of the AP less than a year before, but trained as a First Amendment lawyer, he was made for the fight. He wasn't just fighting for the AP. He was fighting for all of us, journalists, and by extension, all citizens of this democracy. He knew how important this battle was to maintain a robust, free press and unintimidated by anyone, and he did not let up. During a speech at the National Press Club, shortly after the DOJ's actions were revealed, Gary called the agency's actions an unprecedented intrusion into AP's news gathering, noting that a free and independent press is fundamental to a functioning democracy and is what differentiates democracy from dictatorship, what separates a free society from tyranny. The result? President Obama asked Attorney General Eric Holder to make recommendations on the Justice Department's regulations. The Department of Justice began consulting with a number of news organizations, public interest groups, and First Amendment lawyers, holding multiple meetings, all attended by the Attorney General. The Department of Justice revised its guidelines to make it clear that secret seizures of records would be available only in the most extraordinary of circumstances. All of us in the media owe Gary a deep debt of gratitude and appreciation for his leadership during this difficult time. Without his strong stand, which we all supported, I'm not sure we would be where we are today. Now, before coming to the AP, Gary was president and CEO of the McClatchy Company, And that's when I got to know Gary and his tremendous support of the First Amendment. He started his professional career in Miami, working for law firm Paul & Thompson, concentrating on the representation of media firms such as the New York Times and CBS. And he joined McClatchy as general counsel. There he successfully managed, among many other things, the company's portfolio of libel and First Amendment cases. So as you can see, Gary was well prepared for this fight and for continuing the Associated Press's long legacy of fighting government secrecy and advocating for the public right to know. I am incredibly honored to introduce Gary Pruitt and to present him with this award. Gary.
Thank you very much, Gracia. That was a very gracious introduction and very meaningful, especially coming from you. I want to thank the Constitution Project. This is an important award for me because it's given to those who defend the Constitution and the rights it guarantees. And of course, I can't accept this for myself. I'm accepting it on behalf of the team at AP that was part of this fight with me. And we used this dinner as kind of an occasion for a reunion, you know, to kind of get the band back together. And they're here tonight, and they're here at this table. And they deserve this award at least as much as I do. And I wanted to just briefly introduce them. There were 3 great reporters that broke the story, a killer story that only AP had, that started all of this. 3 Pulitzer Prize-winning investigative reporters. Matt Apuzzo, Adam Goldman, and Eileen Sullivan. Would you please stand? But even the best reporters need great editors, and our game had 2 of the best. Ted Brightus, who is AP's National Security and Investigations Editor, and Sally Busby, AP's Washington Bureau Chief. Ted and Sally, would you please stand? And if you go to battle with the DOJ, you better have a good legal team. And ours was led by our General Counsel, Karen Kaiser. And she could stand, please, Karen. Karen is our bright, shiny, tough-as-nails First Amendment lawyer. I was the broken-down has-been First Amendment lawyer that had to be put back together for this fight. And but it was an important fight for us. As Gracia mentioned, the rules that came out of the DOJ, our fight with the DOJ, improved the situation substantially and swiftly. And those of you know in law, that's a rare occasion. And so there was a silver lining to the dark cloud of the subpoena, this broad sweeping of our records. And for the first time, the Department of Justice said that they would not prosecute a journalist for doing his or her job, which is nice to know that in the United States it's not a crime to commit journalism. But it really was one of the most blatant violations of the First Amendment that AP's endured in our 168-year history. And so I wanted to talk just very briefly about what the impact of this case is and was beyond just the circumstances of the case. First, almost certainly my tax return will be audited. We know that, it comes with the territory. But 2, there was a real chilling effect because of this seizure. And it's not hypothetical and it's not theoretical. We had sources dry up, unrelated to this story. Sources we checked in with regularly, didn't want to be associated with us, didn't want their phone number associated with us, and it wasn't just the Associated Press. Journalists at other news organizations told me the same thing. Now, government may love that. I suspect they do. But beware a government that loves secrecy too much. In that case, you only have official sources. You only know what the government wants you to know on the official sources. That's been tried before. That's what Pravda was in the Soviet Union. You don't need a First Amendment if that's the way you're going to run the country. It's not what the framers had in mind when they wrote the First Amendment. Thirdly, we need to keep our vigilance and the media strong and the free press strong as a counterbalance to the increased power of the government and other large institutions because of the power of technology. This is an awesome power that they now have because of the technology, and the genie's not going to be put back in the bottle. We're going to have to act as a counterbalance. Fourth, the government seizure of the AP phone records resonated beyond the shores of the United States, worldwide. I have to travel worldwide for my job. I go around the world. Everyone knew about this case. I know it resonated as kind of a third scandal with the IRS and Benghazi and then the AP phone records. But I was in North Korea visiting our bureau in October. They knew all about the AP phone records case. The freedom of press enshrined in our First Amendment has been a model and an aspiration for countries around the world. And the actions of the Department of Justice in this case could not have been more tailor-made to comfort authoritarian regimes who want to suppress their own news media. The United States does it too, they could say, and it shouldn't be that way. And so as DOJ's chief critic, I do need to give them credit for improving those guidelines. Important for me to do that. And so that we give them that recognition. And I think I'm willing to give them the benefit of the doubt that they acted in good faith. They get single-mindedly focused on these leak investigations and can overlook things, like the US Constitution. So, Gracia quoted me as saying, a free and independent press is fundamental to a functioning democracy. When people like me say stuff like that, a lot of people roll their eyes. And I understand why. Because the media makes a lot of mistakes and does a lot of things wrong every single day. You know, it's, as they say, the first rough draft of history, and it can be pretty rough sometimes. We're churning out a lot. 4,000 photos a day, 2,000 text news stories a day, hundreds of video news stories every day, and that's just the Associated Press every single day. So mistakes will be made, yes, but I gotta tell you something, it's all we've got. It's what we've got, right? It's like Churchill speaking of democracy and saying democracy is the worst form of government except all the others. It's kind of like that with the media. The media is the worst check on government except for all the others. And the framers of the Constitution knew that. And that's the reason they enshrined that protection of freedom of press in the First Amendment. So governments that try to set up a situation where they're trying to force citizens to think that they've got to choose between a free press and national security are making a mistake that ultimately will weaken them, not strengthen them. It's not a real choice. It is a false choice. So thank you, and once again, I want to thank the Constitution Project for this important and meaningful award, not for me, but for the Associated Press. Thank you.
Good evening, I'm David Byer. I have 3 assignments. I will be very brief on each of them. First, thank you to 2 categories of people, the protectors of the Constitution, and there are 3 organizations I'd like to call out, and at the end of the 3, I'd like everybody to give a round of applause to Williams & Connolly, Google, and Bloomberg. Defenders of the Constitution, which is the next category of folks in terms of level of contribution, are the law firm of Blank Rome, the Associated Press, and that the foundation of Frank and Denise Quattrone, and Vincent and Elkins. anybody have an iPhone? You just take out your iPhone. No, I'm serious. Take out your iPhone. Or your regular phone, your old-fashioned one. Okay, this is not in order to take a selfie. You have cards on your seat or on your table that would permit you to text contributions to the Constitution Project. I ask you to only answer one question in determining the amount. If this room, roughly 300 people, if everyone in this room gave according to their ability, I'm willing to bet we can raise thousands of dollars before the end of the evening. And the only question you have to answer is, how much is it worth to you personally to have a Constitution to protect? It's a pretty straightforward question. I think it's worth the money that you'll contribute by text. And then my third role is to introduce the introducer of our next honoree, Michelle Roberts. And I could go on for about 10 minutes to read Michelle's entire biography, but let me call out a couple of things. When a person is called the finest true trial lawyer in Washington, D.C., which is a city that has more than its fair share of really good trial lawyers, that's an accolade I would venture to say anyone would be proud of, but that's not Michelle's only characteristic. One of the most powerful women in Washington, D.C., best trial lawyer, teacher at Harvard Law School as an adjunct. I'll give you Michelle Roberts.
Good evening. Is this working? Yes. I want to talk about a couple of trial lawyers myself. And I'll start by telling you that several weeks ago, I witnessed something which for me, was a small miracle. It was something that, when I was a public defender 25 years ago, I would never have imagined could occur. And let me tell you what it was. The lead editorial in the Wall Street Journal was talking about Brady. I mean, I'm talking the lead editorial of the Wall Street Journal was complaining that prosecutors were not fulfilling their obligation to turn over exculpatory evidence to defense attorneys. I'm talking the Wall Street Journal. Now, it is a bit of a miracle to think that I read the Wall Street Journal every day. 25 years ago, I would never guess that that would be how I began my morning. So that's a miracle in and of itself. But the true miracle for me was this. I wasn't witnessing public defenders in some blue-collar courtroom representing poor people screaming about Brady. It wasn't just about some public defenders and their clients begging the judge to make the government fulfill their responsibilities pursuant to Brady. And it wasn't just about those same lawyers and those same clients being told by judges, counsel, I believe the government understands its obligations pursuant to Brady. Now, case closed. Next question. It wasn't that. What I witnessed was, again, the Wall Street Journal, voices of power speaking truth to power. And what they were saying in that editorial was, government, you're not playing fair, and you're not going to get away with it. Now, I am the very first to admit that there are scores of lawyers, in my view, principally public defenders and principally lawyers that represent poor people, that have every right to claim credit for the fact that we are talking about issues like Brady in the Wall Street Journal. There's no question about that. Lawyers have toiled for years to get prosecutors to be made to pay for their violations of the Brady rule. So many of us can claim credit. However, having said that, I absolutely believe, and there's no doubt in my mind, that the recent and current attention to Brady is in large part due to the efforts of Brendan Sullivan, Rob Carey, and their remarkable team in their representation of the late Senator Stevens, right here in DC. Now, we know that the Williams and Connolly team represented Senator Stevens in a criminal case where he was alleged to have made false statements to the government. And the short story is that at the end of the day, the government found itself having to dismiss the case and vacate his convictions because of findings of prosecutorial misconduct. That's the short story. But I'm here to tell you that the decision and the need to dismiss that case was prompted by the work of that team of lawyers. In other words, the discovery of that misconduct was not by happenstance. It was the result of the relentless pressure that the Williams and Connolly team imposed on the government in their efforts to secure exculpatory evidence. It was their refusal to accept the government's assurances that there was no Brady to be had in that case. Put aside, if you will, all of the written correspondence, the in-person meetings, the telephone conversations that those lawyers had with the prosecutors in their efforts to get Brady disclosed. Put that aside. If you take a look at the docket in that case, you will observe that there were no less than 9 motions filed by that team to dismiss the case or to compel discovery because of the government's Brady violations. There were over a dozen in-court hearings to address the issue of Brady violations alone. And those pleadings and those hearings largely took place in a window of about 2.5 months. It was that pressure by the Williams and Connolly team that gave life to what proved to be literally mind-blowing post-conviction revelations about the government's misconduct. And revelations that included a government witness that testified that the testimony he provided at trial was perjured and that the prosecutors knew. A post-conviction disclosure by an investigator on the government's team that testified, filed a complaint, a whistleblower complaint, that he observed the government making false statements in open court to the court in response to issues related to their Brady obligations. Those disclosures, draped with the pattern of misconduct that the Williams and Connolly team day in and day out ferreted out, proved absolutely critical. At the end of the day, the trial court, Judge Sullivan, was fed up, and he agreed. And the government, clearly seeing the writing on the wall, and undoubtedly knowing that they were about to receive a stern response from the court, cried uncle and dismissed the case with prejudice. Thankfully, that occurred before Senator Stevens' death, but it did not occur soon enough to prevent the loss of his Senate seat. You know, over the years, and this is sad, I have seen big-time, white-collar criminal defense attorneys from major law firms, not all of them former prosecutors, but some of them. I've seen them accept without hesitation the government's word on the issue of Brady. I guess they're all in the same club. Well, not Britton Sullivan and not Rob Perry. They took that big stick of Williams Connolly, and on behalf of the entire criminal defense community, I thank each and every one of you for not being afraid to use it. Congratulations, Brendan.
Anybody who's ever been to court, and there's so many of them here in this room, knows that you don't do anything alone today in the law. You cannot function without the brilliance of a team like this. Please stand up. Williams and Conway team. You might note that they're quite young. Why would we put such a young team on the case of the United States Senator? Well, because we didn't believe they'd indict this senator. So we reached out to the lawyers that were available. And this was the team that made a difference. I want to say to Michelle, I've looked up to Michelle for decades in this town, and part of the honor of being here tonight is to be introduced by you. She's the real thing in the courts of our land. Look, we become lawyers because I think basically deep down we cannot tolerate injustice. And hopefully we use our skills to prevent it. But it does happen. Sometimes I see injustice up close. I even struggle on occasion to avoid tears. It happens to me every year when I attend the Innocent Project fundraiser in New York City. At that function, they traditionally parade up onto the stage 15 or 20 persons, mostly minority, mostly black men, mostly poor people, some women occasionally. And they parade them up and they stand in a line and they have a microphone and they pass it down through each person's hands. And each one of them says words to this effect. I served 27 years in Lompoc prison for a crime I did not commit. And the microphone is passed to the next one, and to the next one. And 20 people later, the emotional impact brings me to tears. Many of the wrongful convictions were triggered by Brady failures. Our team experienced injustice. Our client was one of the most decent person I'd ever met. I never knew him before the charges. He touched the lives of millions of people in this country through 40 years of public service. He was a true war hero who volunteered to fly airplanes in dangerous conditions in World War II when most of those pilots never thought they'd see home again. And prosecutors made a poor judgment to indict him. And then when it occurred to these prosecutors they could possibly lose this case, they violated the Constitution, they violated the Supreme Court's decision in Brady, because they feared losing. They failed to produce Brady material which contradicted their key witness in the most explosive testimony in the case. And a jury verdict of guilty was returned. Thankfully, it lingered only for 5 months until the case was dismissed by Judge Emmett Sullivan, working with his brilliant law clerk round the clock, Addie Schmidt, at the request of the Attorney General of the United States. The day after the dismissal, General Holder went to the same courthouse. He swore in a new group of assistant U.S. attorneys the very day after the dismissal. And he said as follows, quote, "Your job is not to convict people. Your job is not to win cases. Your job is to do justice." I hope they follow his admonition. But I know for a fact that some were not listening. If this can happen to a powerful United States senator, defended by experienced lawyers, in the heart of our nation's capital, in a federal court known for its excellence, it can happen to anyone, anywhere. To you, your children, your family members. That injustice was rectified quickly by Judge Emmett Sullivan, who'd been a trial judge for 20 years in Superior Court and in the federal courts, and his laser-like instincts for fairness. He said early on in the case to the whole assembled group, before we even knew there was a hint of trouble, "You will get a fair trial in my courtroom." Part of the credit is due as well to a new set of prosecutors that arrived on the scene. Instead of protecting the first group of prosecutors who had left the case, they found the Brady. They were shocked, and they turned it over. Part of the credit as well, of course, goes to defense lawyers and the team that you've just been introduced to. But some of it took some sheer luck. Justice should not depend upon luck. You know, my conclusion of 44 years on the front line of trials is that we have the best system in the world. But it is dependent upon everyone doing their jobs. The defense lawyers, the prosecutors, the judges, and the police. It's like an engine to an automobile. One part breaks, and the whole system breaks down. There is so much work to be done. I'm sad to tell you, especially you young lawyers, that my generation of lawyers has fought injustice to a tie. We leave to you the responsibility for making it better, for fixing it. But I am hopeful because I find so many young people dedicating their careers or parts of their careers to making a difference. I've been pleasantly surprised to see that we have many heroes in the law. We sometimes don't recognize them, but we have them. I see them all around. Many are here tonight. There are many that work for the Constitution Project, that dedicate their time and their energy, part of their careers or their whole careers, to protecting the Constitution. This group is defending the Constitution by working hard to have legislation on the Brady rule. It's been a failed rule, as Michelle has suggested. We've been haunted by it for decades, because the whole decision about what is Brady rests in the hands of your adversary. And it takes a real man and a real woman to look at a piece of evidence and hand it over to your adversary. I see heroes in the law firms who today authorize the spending of millions of dollars worth of free legal time by young lawyers so that they can rectify unjust conviction. I see people like Barry Scheck, Peter Neufeld, who founded the Innocence Project and have fought to release more than 311 of our citizens who didn't belong in jail. 300. Are there 10 times 300 that they haven't found and got released in these battles that they fight? Could there be 100 times 300 innocent people in our jails? That process, that fight that the Innocent Project conducts, has taught us all the frightening implications of the innocent being convicted. There are heroes among prosecutors too. We must never think that it's filled with bad people who try to skew the system just to get a win. Most are good, honorable people, our friends, our classmates. But even a few can wreak havoc on our system and destroy lives. Hank Schulke and Bill Shields, that took part of their life to write a 500-page report, are heroes in the law. I urge every young lawyer who enters a criminal courtroom to read it. It's more valuable than every criminal text you've ever seen because it's an anatomy of mistakes, an anatomy of dishonest decisions. made by the government. You have no hope of catching them unless you learn how they do it. And it's set out in that report because Judge Sullivan commissioned their effort to do the report. We should all use what we learned in the Stevens case to become better lawyers. There is no greater responsibility one can shoulder than defending a person in our criminal system. It takes courage, it takes determination, it takes a team of brilliant lawyers, it takes something more too. You have to hate injustice to put yourself through that kind of turmoil, defending a citizen in the criminal courtroom. It was said about the legendary Clarence Darrow that he had the capability to sense injustice. It was described as a rudimentary anger, a capacity to muster all of one's power and to assert it against what one experiences as unfair. So I say to all of you, my colleagues who have been fighting decades like Michelle and I and others here in this room, keep fighting. Be a hero.
Before we proceed to our next and last honorees, that we have to acknowledge Mrs. Catherine Stevens, who is here. Ms. Stevens, if you would. There's Emmett Sullivan. And last set of honorees, also related to the Stevens case. We have someone who, the cliche goes, needs no introduction. Glenn Ivey was the two-time state's attorney in Prince George's County. Before that, an assistant U.S. attorney. He's now in private practice, but everybody here knows the good work he did as prosecutor, and you're the kind of prosecutor we need in office. Glenn Ivey.
Thank you very much. Good evening. To paraphrase Justice Brandeis, sunlight is the best disinfectant. And after presiding over the Ted Stevens case, Judge Sullivan decided that some extra sunlight was definitely in order. So he took the unusual step of hiring a special counsel to investigate the allegations of misconduct. He wanted a thorough investigation conducted by the most seasoned and respected counsel who could announce their findings with unquestioned authority and integrity. So Judge Sullivan turned to our next two 2014 Constitutional Champion Award winners, and they exceeded expectations. They generated a detailed and unflinching report that left no stone unturned. After a 2-year investigation, they brought to light the countless instances of government misconduct that stole away Senator Stevens' constitutional right to a fair trial. But in addition to confirming our worst fears and suspicions about this government misconduct, they reinvigorated and re-energized the call for long overdue discovery reform, not just for individuals who can mount multi-million-dollar defenses, but also for the clients of Gideon's Army. One day when we finally put it in to trial by ambush in federal criminal court, one day when federal prosecutors finally realize that justice can be obtained not in spite of discovery, but because of full discovery, then we will look back on this report as a crucial milestone in the long journey to a fairer criminal justice system. So tonight, please join me in honoring the authors of that landmark report, Hank Schulke and William Shields.
Thank you, Glenn, for your kind introduction. I want to thank as well Jimmy Sloan and the board of the Constitution Project for this award, which honors us perhaps more than we deserve. Judge Sullivan appointed us to conduct this investigation. We did so, in my judgment, thoroughly and fairly. We accomplished our purpose in large part because of the prodigious efforts of Bill Shields, to whom I'm forever grateful. But I feel a tad sheepish about this award. It is described as, for those who defend the Constitution in the face of adversity. Well, as I said, I think we did the job for which we were appointed to do. It was arduous in some respects. It was, to me, personally painful, because as a proud alumnus of the Justice Department, which I remain, I found it very painful to arrive at the conclusions which the facts required us to reach. And I suffered, as one always does in these situations, the slings and arrows of critics. Some who thought we were not hard enough on the department, and some who thought we were not. We were too easy on the department, all of which falls under the rubric, no good deed goes unpunished, I suppose. And so that's the sort of tenor of whatever adversity there was, in my view. I've told this anecdote once or twice before, and so those of you who may have heard it, forgive me. But at one point, somewhat late in the process, Judge Sullivan and I were speaking, and he said, Hank, so knowing what you know now, would you have answered the phone the day I called you? I said, of course, Your Honor. I think what I'm really trying to convey is that while we are honored indeed for this recognition, I think in addition to Brendan and Rob and the Williams and Connolly team, who have my congratulations, the true defender of the Constitution in this case and throughout his time on the bench was Emmett Sullivan. And I should like you all to recognize that. Now, as Brendan has described, what we discovered was a case in which the government's failure to disclose exculpatory material to the defense was rampant. It was, we concluded, in several respects, willful and intentional. It's not, however, the only such case. One would think that in the wake of the outcome of the Stevens case, and in the wake of our report, serious change would have occurred at the department. I don't believe that's so. it is true that Attorney General Holder and his senior subordinates redoubled their efforts to educate prosecutors across the country. And I think they probably have put in place a program to accomplish that, which is about as good as it could be. But this is not, in my view, about education. This is about the recognition that trial lawyers, all of us, want to win. And in a perverse way, the higher the visibility of the case, the greater that impetus is. And so you have prosecutors, not all of them to be sure, but you have many of them, who say, this little piece of garbage, and do I have to turn this over? No, I don't think it's material. And that's the standard we're going to apply. Of course, they don't know precisely what the defense will be. They don't know how the case is going to develop. But they make this judgment up front, no, this is not material, and therefore we are not required to turn it over. This policy is actually articulated in the U.S. Attorney's Manual, which had been revised in the wake of the Stevens case. And it provides that prosecutors should err on the side of disclosure. And even if, in their view, Brady and its progeny don't necessarily require disclosure, if it appears to the prosecutor that this information might well prove to be useful to the defense and perhaps exculpatory, then you, prosecutor, in your discretion, we suggest ought to turn it over. The policy statement goes on to say that this statement of policy does not have the force of law, and it invests no rights in anyone. So what we have ultimately is a policy of unfettered discretion. I believe, based on my personal experience trying cases over the years, that most prosecutors exercise that discretion honestly and fairly. But there have been, since the Stevens case, at least 15 fairly high visibility cases of which I'm aware across the country, which have been reversed on appeal for non-disclosure of exculpatory information. So the discretionary policy doesn't work, it seems. Now, there have been efforts to address this problem through an amendment to Rule 16, which Judge Sullivan and Judge Friedman, who was here as well tonight, have championed. And there has been legislation proposed by Senator Murkowski from Alaska, which would provide a force of law to a requirement of disclosure of exculpatory information. Hasn't happened. Hasn't happened in large part because the Justice Department opposes it. The Justice Department says, well, if we had a mandatory rule or a statute that required disclosure in certain defined circumstances, that would just breed more litigation. Well, isn't that what we do? That's what we pay you to do. And would you rather engage in the post-conviction litigation in which you've been engaged now for years trying to defend your non-disclosures in the trial court? Makes no sense to me. The Constitution Project has supported efforts at this sort of reform. I think those efforts ought to continue. But it's going to require yet another spark of some kind. You know, had it not been for the Stevens case, Senator Murkowski, of course, would not have proposed this legislation. And while there were a number of long-time friends and colleagues of Senator Stevens who remained in the Senate and on the Judiciary Committee, it had a half-life of about 6 months before the issue basically died. So I believe we, all of us who have an opportunity to participate, whether it's by way of contribution to the Rules Committee, or whether it's by way of trying to interest members of Congress, I think that's what we ought to be doing. So I thank you very much. And Bill, would you please?
I feel like I'm in the company of giants here, but I want to first thank Ginny Sloan and the Constitution Project for this surprising and delightful award to Hank and me. And I also want to echo Hank's comments that we would not, any one of us, be here but for Judge Sullivan's tenacious and stubborn refusal to just accept, oh, let's dismiss the case and call it a day. He wanted to know what happened and was tenacious in that and insisted on finding out what happened. And as you know, it's very easy when the government gives up to take the dismissal and run and get out of the courthouse. This judge wouldn't let that happen, and he wanted to know exactly what happened. I'm not going to rehearse Brady to you. I think I'm in the company of everyone here who knows what Brady is and what a painful system the American judicial system is to go through if you're a defendant. But I feel confident or hopeful that what we did in Ted Stevens' case is going to contribute something to what I see from reading the papers and reading the decisions, that Brady is getting more attention now, and people are realizing that it's a critical threat. The government has a monopoly on all the information in most criminal cases. They control the flow entirely, especially with people who can't afford private lawyers. They're not in a position to hire a team of lawyers. They're not in a position to hire investigators. They rely on the government. The government fails to do that. It failed to do that in the Stevens case. And I think the public is becoming more aware of it. And the courts gave us Brady. It's their responsibility to enforce Brady. And I detect a change in the courts. Recently, there was in the last year, in the anniversary of Brady, Judge Kaczynski, who's here tonight, and I just wrote a piece of one of his dissents in December of last year from a petition for a rehearing on bond, where material was withheld from the defense that would have impugned the integrity and credibility of the government's expert. And the panel decided that it was harmless error, it was not material, it made no difference. And Judge Kaczynski dissented from the denial of the petition for the rehearing on bond. And his opening line was that there's an epidemic of Brady violations abroad in the land. Only judges can put a stop to it. And that is a matter of fact. The government writes the rules. They determine what our rights are, what discovery we get. They help the Congress write the legislation. They're involved with any revisions of Rule 16. So the government has complete control of the information, and it makes the rules. And what the courts and defense attorneys do their best to have happen is have them comply with their own rules. The Constitution is our rule. The court gave it to us, and it's time for the courts to enforce that for the benefit of the defense. And Judge Kaczynski went on to say, due to the nature of a Brady violation, it's highly unlikely wrongdoing will ever come to light in the first place. In the rare event that the suppressed evidence does surface, the consequences usually leave the prosecution no worse than had it complied with Brady from the outset. Professional discipline is rare. Violations seldom give rise to liability for money damages. If the violation is found to be material, a standard that will almost never be met under the panel's construction in that case. The prosecution gets a do-over, making it no worse than if it had disclosed the information, the evidence in the first place. Quote, continuing the quote from Judge Kaczynski, we must send prosecutors a clear message: betray Brady, give short shrift to Giglio, and you will lose your ill-gotten conviction. Unfortunately, the panel's decision sends the opposite message. And I'm going to be very brief, unlike our report. I'm almost done. And last month, March 25th, from the 7th Circuit, Chief Judge Diane Wood, in the opening line of the decision, U.S. v. Morales, a wire fraud case where there was a Brady violation claim. In her opening paragraph, Judge Wood from the 7th Circuit wrote, more than 50 years ago, the Supreme Court announced in Brady v. Maryland that prosecutors have a duty to turn over, upon request, any material evidence that's favorable to the defense. One would think by now failures to comply with this rule would be rare, but Brady issues continue to arise. Often non-disclosure comes at no price for prosecutors because courts find that the withheld evidence would not have created a, quote, reasonable probability of a different result. And here's the line to pay attention to. We must leave for another day a closer examination of the incentive structure created by Brady's harmless error exception, because the case before us is another in which the Brady violations do not drive the result. To me, reading that opinion from a chief judge in the 7th Circuit, that's a shot across the bow that maybe times are changing. And my only hope is that if they do change, because Brady is a critical right, if Brady fails, if defense doesn't get material it's entitled to under the Constitution, then the system fails, as it miserably failed for Ted Stevens. Thank you.
This has been a spectacular evening, and I'll be brief. First, I'd like to thank one last time our three groups of honorees for all that they've done. As we heard tonight, whether it's as we heard from Gary Pruitt on the issue of the free press, certainly the outcome in terms of the change of rules was a great result. But there's a lot of work that has to be done over time to ensure that there is transparency in what the government is doing. And Bill, I think you summed it up quite well on the Senator Stevens' conviction was fortunately reversed, and through the hard work of Brendan, Rob, and your team. But Hank and Bill, the report that you wrote is really a testament that we all need to read. But the cases that continue tell us that there's a lot to be done in terms of protecting the Constitution. And that's why it's fantastic that there's so many of you who care. And that's why it's fantastic that we've got an organization run by Jim Sloan and a great staff at the Constitution Project that do this. So let me thank, again, our sponsors. I also want to give a special thanks to Jones Day, our partner Larry Rosenberg, who's on the board of the Constitution Project as a Jones Day partner. Thank you very much for hosting us in this wonderful site. Thanks again to Jenny Donnelly and all the staff for helping put together a fantastic night. A couple of things just to ask on your way out as you enjoy the gelato in a few minutes. Again, we've got a lot of hard work at the Constitution Project. We certainly appreciate all of the firms and organizations and individuals who have generously contributed to make tonight's gala our most successful ever. But as David Byer pointed out, there's still time. You can text 41444 and then put in a really big number, please. But please help support the Constitution Project. If you don't like to text, there's envelopes which you can leave on your way out or send in the mail. But it's not just about money. It's about your help. Many of you volunteer and assist the Constitution Project on our various committees. There's a number of firms represented in this room who helped by writing amicus briefs. And we appreciate all that. And if you're looking for ways to help, please just let Ginny or me or anyone associated with the Constitution Project know, and we're glad to take you up on your help. I last want to say we have started last year a fabulous Young Professionals Committee, some of whom are in the room, including I think that both chairs are here, Alex and John. It's a great group of young professionals who care about the Constitution Project. They put together a little trivia game on the Constitution, which there's cards and a basket over near the bar, so next time you're getting a drink, pick one up. Please don't use your smartphone to Google the answers, but do your best. There's some tough questions in there. Put it in the basket, and the winners will get something from the Constitution Project. So once again, thanks again. Congratulations to our honorees.